Evening. Welcome to our next Chamber of Condos. This one had some fits and starts. We had planned this originally 5 months ago, and had some technical issues and some logistical challenges. So we put this aside, and here we did. We want to slap that in. Jay, welcome. Okay. Chamber of Condos, we're also condo rights workshops, a little bit of a rebranding, but we are now going on 7 years. Wow. So, I want to introduce Robert Yaffe, who is my old faithful, and he is a board certified attorney, also a council member in the town of Bay Harbor Islands. So he also serves on the Board of Rules and Appeals, which is a very important body for overseeing the building code and recertification process. How many people here have gone through or are going through recertification? Okay. All right. You're the lucky ones, right? Well, now it's expedited, so if you haven't gone through it yet, you're sure to go through it very soon, right? Okay. That's true. Okay, so my name is Dana Goldman. I'm sure everybody in the audience knows who I am. So we're here together through thick and thin. Okay, quality of life. We spent a good deal of time discussing the legislative amendments in our post-Champlain Towers world order. And that's been the subject of much discussion. You know, we went from the COVID years to now Champlain Towers and the aftermath, and now all the legislation. Some might call it a bit of an overreaction, and the consequences of that, and some of the challenges that condo associations face dealing with the mandates and the requirements. So I think we're gonna pivot this time around to something that is welcome. We're gonna pivot to quality of life. That's where we started many years ago. Okay, so I love this topic. It's the nuisance cases. Does anybody here, just show of hands, have you ever dealt with a nuisance action or a nuisance case, or know what even nuisance is? Anybody here know a little bit about nuisance? If you're on the board of directors, I see Mr. Raymond, if you're on the board of directors, I am sure, whether or not it's labeled as a nuisance, I'm sure you've fielded complaints in the past about barking dogs, noisy, Mary Jane, secondhand smoke, cigars, tap dancing on the floor. Right. We even have a case, one of my favorites, about the helicopter landing on your roof. Okay. Landfills next door, it runs the gamut. But chances are, if you served on a board or if you've been in kind of an association, somehow, somewhere, somebody is maybe interfering with your rights as a property owner. And that's what this is all about. Okay, what is a nuisance and how is it defined under Florida law?
Well, I would say that probably every declaration of condominium has a nuisance provision. You can't do anything which causes a nuisance to anybody else. For one example is no nuisances shall be allowed upon the condominium property, nor shall any use or practice be allowed which is a reasonable source of annoyance to unit owners or which interferes with the peaceful and proper use of a condominium property by any condominium owner. So as Dana said, this is a quality of life issue. You should be able to live and enjoy in your unit and enjoy your unit and not be bothered unreasonably. That's an important word, unreasonably, by any of your neighbors. Now, understandably, when you live in a multifamily residential building such as this, you have people below you, above you, on the sides, and you're going to hear noises and things from time to time which may bother you. But the question is it unreasonable?
Okay, first of all, there are two types of nuisance, basically. There's a public nuisance and there's a private nuisance, right? And a nuisance really is a tort, right?
Right.
Okay, so it's something that causes damage or injury to another. In this case, it's the injury to your right of enjoyment or an interference with your right of enjoyment of your property. A little different from a trespass, right? A trespass is an invasion of your property, but a nuisance is an interference with your right of enjoyment. Okay, a public nuisance. A kind of is a condition dangerous to health, offensive to community moral standards, or unlawfully obstructing the public in the free use of public property. And again, that issue I saw a case on somebody lived in a bunch of homeowners. They were living in an area, and then all of a sudden the landfill wanted to expand. Is that a public nuisance?
It certainly could be.
Okay. We build a landfill, they decide they want to expand it, and it's right in your backyard.
Right.
Arguably a nuisance, right?
Right. If you're going to be odors and dirt and garbage, yeah.
So a private nuisance, by distinction, in interference with a person's enjoyment and use of his land. So one is to the public, and one is more at the individual level of redress. So, another definition. The law of private nuisance is bottomed on the fundamental rule that every person should so use his own property as to not injure that of another, as expressed in the maxim, and I didn't take Latin in high school, sic utere tuo ut alienum non laetus, and that anything which annoys or disturbs one in the free use, possession, or enjoyment of his property, or which renders its ordinary use or occupation physically uncomfortable, is a nuisance and may be restrained. So that gets into the idea of, if there is a nuisance, what do you do about it?
Right. Theoretically, there could be damages if you lose the value of your property, or if you have to take measures to remediate the nuisance because your neighbor refuses to be a good neighbor, so to speak. But generally, what you're looking to do from a legal standpoint is get an order from an arbitrator or a court telling the person who's creating the nuisance, you cannot do this anymore. Stop it, or there will be other consequences. And you hope that if there's a court order or an arbitrator's order, that the person who's creating the nuisance will obey, because he or she may be hit with legal fees as well. And that is one thing under the Condominium Act. When a unit owner sues a unit owner, there is a possibility to recover attorney's fees.
Okay, but it's mostly for equitable relief, right? An injunction, you
Right.
want to enjoin or restrain the behavior or the activity.
Right.
It's really not about, well, the dog was barking and I need $100,000 for that barking dog. It's like, I want that dog to stop barking, right?
Right.
Okay, do you have a question? Go ahead.
Are you talking about only common areas, limited common areas, or inside the units?
Good question.
There are actually different types of nuisances. There are nuisances which people create in common areas. Interfering with the operation of a condominium can be a nuisance. But there are also nuisances that are created neighbor versus neighbor, so to speak, where one neighbor is doing something which constitutes a nuisance because that person is disturbing his or her neighbor. Unreasonably so.
But the nuisance can occur whether you're in your property or I suppose on a common area or a common element, right?
Right.
It can occur anywhere. And
Yes.
there's a nuisance when somebody has an air conditioning unit and it makes a loud noise, or maybe it's the neighboring property. Maybe the smoke is coming out of the adjacent building, right? But it could emanate from anywhere. It just disturbs you wherever you're located, whether it's
Right.
in the common areas or in the unit itself. Okay, go ahead.
I have 4 questions. So, when you say go to an arbitrator, do you mean first after the association has ignored it, or do you go through the board first, or?
Well, that's something that we're going to talk about, is whether it's an association issue or whether it's a neighbor versus neighbor issue, because not every nuisance is something that the association has the obligation to enforce or can enforce. So a lot of times it's a neighbor filing a lawsuit against a neighbor, for example. 2 unit owners cannot go to arbitration. You can't go to arbitration against each other because that's not within the jurisdiction of condominium arbitration. So if you have an issue with a neighbor, it's most likely you may be able to try to mediate it, voluntarily. If that doesn't work, you can go to court and seek relief in court.
That's very important because it's true. And oftentimes we will get calls from owners saying, hey, I have this problem with my next door neighbor. There's, they didn't put it's the floor mounting, they never put the floor mounting in, or, it's very noisy. They come in, they're very boisterous, they got kids riding tricycles or so forth, and the association won't do anything, right?
Well, and then they got half-hearted attempt, but ultimately they say, there's no specific violation that we can point to in our declaration of condominium or our rules or regulations, so that's really something that you need to resolve with your neighbor. So you have to look at what the alleged violation is, what the violation is, and is there anything in your documents that governs the conduct that's causing the nuisance.
Absolutely. So let's talk about that. Is there a nuisance provision in your governing documents? And the answer is typically yes. And I'm going to give you a couple of samples of stuff that I put in my documents, whether they're homeowners association documents or condominium documents. So here's a sample. No nuisances as reasonably determined by the association shall be allowed on the condominium property, nor shall any use or practice be allowed which is a source of annoyance to residents or occupants of units, or which interferes with the peaceful possession or proper use of the condominium property by its residents or occupants. Again, condominium property, very broadly defined, right? Not the unit, it's the overall property. No activity specifically permitted by this declaration shall be deemed a nuisance. Here's another one. No nuisance or any use or practice that is source of annoyance to others interferes with the peaceful possession and proper use of this community or this condo is permitted. The final determination of what constitutes a nuisance shall be made by the board in its sole discretion. No firearms shall be discharged. No playing of loud music or gathering in front of homes or common areas is permitted, or its immediate family. No firearms, nothing shall be done or kept within the common areas or any other portion of this community, including a home or lot, which will increase the rate of insurance to be paid by the association. So you see a couple of things. These provisions in your declaration of condominium or your declaration of covenants, they're broad, a little fuzzy, a little over, right? Not very specific, right? And that's good and bad.
Right.
Because it's good in that it's all encompassing and it covers a lot, but it's not so good because it doesn't really clearly define activities which could be a nuisance, whether it's a barking dog or it's the decibel levels or, where the noise, right.
Walking around in the unit, there's no carpet, for example.
And so then if whatever's in your governing docs, your declaration, now you got to go to your rules and regulations, right? And you got to hope that in the rules, there's some definition about dogs, about, decibel levels, about noise, about other things, right? Because without specificity, what is it that you're enforcing, right? Are you going to just leave it up to the board? Or again, is the only recourse that owns a court to file for an injunction? That's two things, right? Is there a nuisance provision in your documents, or does the act violate any specific rules and regulations? And will the association enforce its own rules? Now, it could be, if the act is considered a nuisance, it's also, under Florida common law, it could be a breach of covenant, right? It's a breach, it's not only a nuisance, but it's also a breach of your documents.
Right.
So how do these nuisance cases typically arise in the condominium context? Surely you've had some along the way.
It can be anything. In my experience, I've had people complain about the TV being too loud, or maybe the neighbor has children and they ride their tricycles in the unit, or they're bouncing balls or running around. At a circumstance where somebody came to me and they said, my upstairs neighbor gets up at 4:30 every morning and to go to the gym early, and he's clumping around, waking me up every morning at 4:30. There are, the secondhand smoke that we talked about, people just, playing their stereo loud. Sometimes it's just talking loud. These are all types of incidents which arise frequently between neighbors. And if there's a specific rule, let's say, for example, there's a rule that says you can't play loud music after 11 and before 8 a.m. But, your neighbor has got the stereo going or has the TV really loud at midnight, 1 o'clock in the morning, that's a violation of the condominium's rules. But, walking around at 4:30 in the morning is not necessarily a violation of any rule. So you have to try to figure out how to deal with that.
So who has standing to enforce a nuisance claim or action? Is it the unit owner, the association? Is it really the association's job to take it? And how does that work? Do they typically arbitrate, or do they?
In my experience, it depends on the association. Some of them will say that any issue between neighbors is an issue between neighbors, will leave us out of it. Unless you can, pinpoint some rule that is being violated, which the association has an obligation to enforce, because the declaration of condominium, the rules and so forth, contract between the association and the unit owner, they have an obligation to enforce those provisions. But if it's too vague or there's a way out, sometimes management or the board will say, you guys deal with it on your own, go to mediation, work it out between neighbors. So it really, frankly, depends on the association. Some associations are more apt to get involved because they just don't want the controversy in the building. But some of them will leave it between neighbors.
I wanted a distinction between like 718-303 and 718-1255.
Right.
So how does the arbitration, how does that work?
So if you're in violation, if you as a unit owner are in violation of a rule or some provision of the declaration of condominium, the association can send you basically cease and desist letter, or what we call a pre-arbitration letter, saying, you've regularly been playing your music very loud at midnight, 1 o'clock in the morning, and if you don't stop it, we're going to file a petition for arbitration. So, you must, when you're playing music, you need to stop immediately. And if it continues, we're going to take it to arbitration. So that's what's called the pre-arbitration notice, which is a requirement before you go to arbitration. If you continue to violate, the association will file a petition for arbitration with the Division of Condominiums. There's a form, petition, which is filled out. It goes to Tallahassee along with a copy of the pre-arbitration notice and the governing documents. And if the arbitrators determine that it is a matter subject to arbitration, they will have the respondent, the unit owner, file an answer. And they must file the answer within 20 days. And then there will be hearings, and there may be mediation, and ultimately, if the parties can't resolve them between themselves, there may be basically a trial where the arbitrator is serving as the judge, and the arbitrator will issue an order either finding that there was a violation or there wasn't a violation.
So are you subject to the pre-suit mediation? In other words, if you want to file, it has to go to mediation first, or are you required to mediate these types of nuisance disputes?
Right. You don't have to mediate. You basically have the choice. You can seek mediation before you go to arbitration, or even during arbitration, you can request mediation and the arbitrator can appoint a mediator to try to resolve the dispute before it goes to a full-blown arbitration trial or hearing.
If you decide what is better, is it better to go to arbitration, or is it better to just go to court and get like an emergency file for an injunction?
So depending on the nature of the dispute, if it's subject to 718-1255, which is the alternate dispute resolution provision of the Condominium Act, you cannot go to court to solve some of those disputes. You have to go to arbitration. You can choose, and the statute itself says, before you can go to court, you either have to go to arbitration or do mediation. If those fail, then you can go to court. The problem that I find with arbitration is that generally it's non-binding. So you go through this whole process, and the losing party can then say, I didn't really like that result. And that losing party then has the opportunity to file a complaint in circuit court, which is called a complaint for trial de novo, a new trial. and it's starting all over again. As long as the unit owner does that, the losing party does that within 15 days of the entry of the arbitration order, they can do a trial de novo. If they don't do that, then it becomes a binding order. So, there's a way out of it for the losing party, which delays the resolution. There is
So why arbitrate if you know that you're not gonna get the final edict or the final answer?
because you're required to go to arbitration.
Okay.
Now, in certain circumstances, okay, well, a lot of the nuisance cases, particularly the arbitration cases, deal with unit owners who don't take care of their units, right? Hoarders, okay? Piles and piles of garbage, they don't clean, it smells, there's roaches, there's all types of things going on, right? You think you'd be able to go right to court, but what happens is you got to go through the arbitration process. You file your petition for arbitration, and you, at the same time, you can file a motion for leave to go to court. The arbitrator can permit you then to go to court to get an injunction, and then come back for arbitration if necessary to resolve the dispute. So I've had that happen before.
That's interesting. So, okay, let's talk about some of these types of nuisance cases. So, we'll have a seminal case, Roebuck and Sills, where there was a noisy pool pump and annoying exterior lighting pool heater on the side of the house close to a master bedroom window. And that, in that case, this is one of the main cases where, it's a pool pump and an exterior lighting pool heater, and then that was considered a nuisance, right?
Correct,
It was considered actionable. That's Roebuck and Sills. One of these cases actually that at least I've looked at, have come from what's called the 3rd DCA, and that's Miami. That's where we live. We're under the 3rd DCA. Your question?
Yes, when does the Williams community advice come into play? Before or after arbitration?
That is a very good question, because it really is. If you think about it, when you have these types of nuisance things, the question is, have you exhausted the remedies internally, or how does that grievance procedure, that internal procedure play into?
Well, if the nuisance constitutes a violation of a particular rule, you don't have your dog on a leash, or you're not cleaning up after your dog or something, for example, which is a nuisance, the association can levy a fine against the unit owner up to, $1,000, I think, $100 a day, up to $1,000 for repeat violations. But, that doesn't necessarily get you anywhere. The fine does not constitute a lien, so, they can't foreclose the lien against your unit because of a fine. So really the only thing the association can do is go to small claims court to try to collect that. They may be able to suspend your certain rights that you have as a unit owner, but that's not necessarily going to be the most effective remedy for an ongoing violation.
Right, but that is the association is the party, right? So if you're a unit owner and you're complaining of the barking dog that's next to you, in order to go through that internal grievance procedure, you have to plead that to the association, right?
Right.
You can only beg or request or direct the association, hey, what are you going to do about that? And in fact, you get into a situation, my personal experience, sometimes, these violations committees, they don't equitably enforce or go after certain owners to the detriment of others, and you can always get into a selective enforcement problem, right? The question is, even if you have rules and even if you have a violations committee in your association or, some sort of enforcement committee, the question is, do they often meet? Are they uniformly issuing violations? Are they not selectively enforcing? How robust is the internal enforcement process, right, in your association?
And a lot of associations, even large associations with 100 units or more, can't find 3 people who are willing to serve on a nuisance committee or a nuisance committee because they don't want to be fining their neighbors and so forth. So, so that can be difficult at times.
Right. Have rules in place You may have a violations committee assembled if you get people who have an interest in doing it, but you don't have an ongoing or consistent policy of going after violators, right? And that's also, that's very much the case, right? And so here you are, if you have an issue with your neighbor, you have to really depend on your association to handle that and handle it consistently, right? And not always so prevalent or so easy to do. Okay, there's another case, Bow versus Coronado, and that was the noise from the uninsulated terrazzo corridor of the lobby above their unit deprived them of the free use and enjoyment of their unit. So there was a restraining order, the trial court dissolved it, and then the appellate court reversed. And so even though the developer created the nuisance, it did not relieve the association of the responsibility to abate the problem. Right? And so that's the nuisance case where, again, there's noise, and there's noise from something that's, it's a structural or a defect, and, how they were constructed, but it doesn't, if there's a nuisance that's created, it doesn't leave the association off those. Level of smoking in this particular case was so excessive.
Right, that's the word that the judge used, excessive.
Right.
Like, is the smoke excessive?
Right. So as a association, when people come in and complain basically about the noise and everything going on, sometimes we can resolve issues like, for example, fire hazard. I would just call the code enforcement and, deal with the city. They come right away. That's not a problem. But the issues, for example, we have one of the person that opened the door and don't want to close the door because they enjoy the AC in the hallway. They don't want to use the side of it. So something like that.
Wait, we're not getting any names. No names. No unit numbers. No addresses, right?
So in that case, you can adopt a rule. Adopt a rule. You can leave the door open.
Okay.
And then find that person.
So basically, everything relates on my part. Everything that's in the rules, I can enforce. When it's not in the rules, there's nothing I can do, and I have to refer people to arbitration, which you mentioned, between the neighbors, if that's posing, or association itself.
Right. If it's between neighbors, it's not arbitration. It's either going to be mediation or going to court.
Correct.
There's what I call a reasonableness test, right? What is reasonable and what's unreasonable? And of course, like anything else, a question of proof. Because I had a client come to me and say, it's so noisy. And I said, well, are you going to get an acoustical engineer? And go find an acoustical engineer. What are you going to, there's ambient noise in different types and different levels and so forth. So is the activity it doesn't unreasonably interfere? And then there's a question of how do you prove it, right? How do you prove your case?
So here's an example, right? This is condominium on Miami Beach. The owner of the unit, was actually the son of an owner who was living there, played his music relatively loud and had the TV relatively loud, but nobody ever really complained about it. And then a family moved in next door and they had a baby. And they complained all the time because when the baby took a nap, if the TV was on or the music was on, the baby would wake up. And it really became a very heated dispute between the two neighbors, such that, I went there one day along with the property manager and board members, and, I went to the next door neighbor, and we had the other neighbor turn up his volume to a certain, degree, and then we tried to figure out how low did the volume have to be not to, cause a disturbance to the neighbor. So you get some type of really wonky situations where you're trying to work it out, and it doesn't always work out. Here, in this case, it ultimately worked out. They figured out how to live next door to each other. I think he moved the TV. One guy moved the TV to the other wall or something. But there's a lot of disputes.
Here, go ahead. Use the mic.
The building where I live is 40 years plus. And at that time when it was built, so I said the building where I live is 40 years old plus. And at that time, some regulations or some way to treat the environment were different. So now, or for example, we have a very poor acoustic isolation. Personally, our family, my wife and I, we terribly could live in the noise that is produced from the above. And is there any way, a legal way, to push these people to install something that will reduce this nuisance?
Because if, as you say, the building was 40 years old and the sound attenuation regulations back when the building was built were not what they are today. And if the floor has been there for 40 years, you really can't make them, take up that floor and put in some type of soundproof or sound attenuation system to reduce the noise.
You can.
You can.
You can. The question was, is there a legal way to
No, my answer to the question is no, because it's an existing, and you can't force them to pull it out. Now, if they decide to put in a new floor, then they would have to comply with the current laws and regulations and whatever sound attenuation provisions may have been put into the governing documents. But I try to, resolve those disputes by, don't walk around, the unit with your shoes on or put area rugs down, things like that. But, it becomes very difficult if the upstairs neighbor doesn't want to cooperate.
Right, and so we, all the newer generation documents have soundproofing requirements that anytime you install a flooring, if it's not the developer that's installing it, if you want to install it, you have to have a certain level. And so I don't know whether it's their city code or they have certain specifications, and then of course architectural or board approval for that. The problem sometimes is that if they don't have it, you can't force somebody to come into your unit to test it, because you'd have to do disruptive testing to see what's underneath it.
But I think if the code of the city of Sunny Isles Beach requires certain sound attenuation when tile or wood floor is installed, and you can determine by the public records that no permit was pulled, you can then go to code enforcement and say, my neighbor installed a tile floor and there's no permit. You need to go check it out, and they will do some, or they know.
Can they force their entry, or what happens if they get to the door and the building department comes and they say, no, we're not going to let you in? Because I had that situation in one of the buildings in Sunny Isles where they wouldn't let it in, and their attitude was, I don't have any extra marble pieces. I'm not going to let anybody go in and.
I think they can still post a notice of violation for doing work without a permit, and you're going to have to answer to that violation. You may be fined.
So what you're saying is it's not fatal that it's not in your governing documents, because there could be a city
code.
Building code or city or county building code specification that they did not meet. The question is, was it the original flooring? How would you know? Or was it something that was subsequently installed?
Right, there were witnesses, and they saw the material coming in, the workers coming in, and it's in my experience, you need a permit if you're changing a floor in a condominium unit, no matter where you are. And so if the work is done without a permit, then that's going to rise to a level of a code violation.
Could your question back? Do you need a microphone or?
No, I can speak. I think I can speak pretty loud.
Okay, yes.
Can you hear me?
Yes.
We can hear you. We can hear you.
Good. In that situation, if you find that the noise from upstairs, if you're living with something that's going on, and you find that they did replace their floor within, say, the last 8 years, do you go after the person? Do you go after the board? Do you go after the condominium association because they didn't enforce that they had a lining or whatever it is, soundproofing on their floor. They didn't go because they didn't do it properly. Who then do you go after? Do you go after the neighbor who says, I'm, everything is fine and I like your code? Or do you go downstairs and help you? Relate it to the board editor. So who's at fault? That's what I want to know.
So I would look at the governing documents and see if the governing documents have a provision which requires sound attenuation when you're installing a wood or a tile floor.
Did they change within the last 10 years?
No, it depends on what the Declaration of Condominium says. I mean, the Declaration of Condominium was recorded as a lot of Winston Tower for maybe in 1980. They probably didn't have that type of provision. Now, it may have been, amended since that time, but the city generally has an ordinance which requires a permit to change out a floor and probably has something in its code that requires sound attenuation. So if there's nothing to enforce based upon a violation of the declaration or the rules, then go to the city or do both.
But that's against the owner, not the board, right? If there's a requirement in the documents,
It sounds like it's against both.
Well, I would say this, look, most condominium associations require, if you're doing work in the unit, that you prove that you have a permit and that the workers are insured. So if the association is not enforcing that basic rule, then there may be, an action or a way to go after the association because it didn't enforce its rule and it ultimately permitted a unit owner to do unpermitted work. So you may have an action against both of them.
very good. Okay, we know all about those noisy, what I call the noisy neighbor, right? That's a big one. Okay, this is a seminal case, Davis versus Levin. The sole question in an action seeking injunctive relief to abate a nuisance is whether or not the use made of property by the one complained against is reasonable under the circumstances. This question includes also a determination of whether the annoyance and disturbance complained of have resulted in injury to a legal right to the person complaining. Mere disturbance and annoyance, as such, do not in themselves necessarily give rise to an invasion of a legal right. So I think the point is, it's the degree to which you can prove the nuisance, right? Is it, as we say, excessive? Is it beyond a mere annoyance, right? If the dog barks once at 4 o'clock,
Right.
different from the dog all the time. Now, the current documents, when it comes to dogs, barking dogs, the current documents that, lawyers draft really do have specific ability, like the right of the board to remove a dog that's a nuisance or, a breed or a nuisance or some issue. Boards have a lot of discretion when it comes to dogs. Whether or not they exercise them, that's another story.
And if you're,
Even if they're ESA and service animals?
no. No, let me modify that, okay? An ESA or a service animal is not considered a pet, but it's not considered a pet,
That's
okay?
correct.
But it cannot become a nuisance. So if it's an ESA or a service animal and it's barking incessantly, then you can try to have that dog removed. Now, typically in the arbitration cases, they're looking for not the most severe remedy to begin with. So it might be that you have to have the dog trained, or that the dog has to have a bark collar or a muzzle on, or something like that.
Didn't you have a case like that where
Yeah.
the dog was the biting dog?
And when it's still going on, but
The
But-
dog
but-
bites. Wait, if the dog bites, is that a nuisance? And the dog barks is one thing, but what about if the dog bites another owner?
right.
Property.
Well, in that case, the owner of the dog said that the person that was bit provoked the dog because they came over and they started petting the dog, and the dog is like, snapped at the person. I don't know ultimately how it's going to play out. But just because it's an ESA doesn't mean it can be a nuisance. But in the arbitration cases with pets, they're trying to find a way to resolve the issue without having the pet removed.
Oh, that's interesting. In other words, they don't, even if my documents say, board can remove that dog no matter what, and they have unfettered discretion to take a dog off the property if that dog is creating a problem or a nuisance, right? Those are my documents.
Right. So the question though is, how is the board going to exercise that authority to remove the dog? They're going to come into the unit and grab the dog and bring it to the town. That's not going to happen. So what they're going to do is file a petition for arbitration or perhaps go to court to try to get the dog removed. But again, I think that they're going to look for a remedy that is not as severe as removal. If it's a repeat offense, right, and then that's a different story.
Right, late night, ongoing.
Yes.
So that's a very good question because I know in the Arlen house there is a lot of drama about dogs, right? Right, and so you can have a no pet building. I think the 700 has that, no pets. I'm sorry, Arlen House has a no pet.
Yes.
No pet. I think there must be other buildings that have no pet rules, right? But then, how do you circumvent that rule? You get an ESA. And how broad is the category of disability or emotional support that anybody, right? If you have high blood pressure, you can get.
It takes about 15 minutes to get a certification. You go online and you pay $80 or whatever it is. So people get around those rules, but it becomes very expensive for an association to try to litigate whether it is in fact an ESA or not. That can be expensive, so they try to avoid it. Another problem that I've encountered is people letting their dogs out on the balcony, and then we'll go on knees on the balcony, and so that's another issue. There have been orders, entered by arbitrators. You cannot let that dog on the balcony. If the dog goes on the balcony, then it does this again, then you may be facing removal of the dog from the building, by an order from the arbitrator.
So I see those and I put those in my documents where say don't leave the dog unattended,
Right.
Don't leave the dog on the balcony. Dogs must have a leash when they're in the common areas, and you have to pick up after your dog and so on and so forth. So you have in these documents, you have a lot of specificity, right? Because you
Right.
want to have rules, and they would equally apply to the ESAs and the service animals, correct?
Correct.
To create more of the issue, right, than the service animals. Because service animals are theoretically much higher level of training, right?
Yes.
So if it's a non-pet building, yes, not friendly, how can we make a rules? It's like nonsense because it's a no-pet building, yes, but we are making the rules.
Well, the reality is that non-pet buildings don't really exist anymore, regardless of what you have in your declaration, because there's always going to be somebody who has a service dog or has an emotional support animal, and so there's always going to be pets. It's rare that you're not going to find somebody coming in, even a tenant coming in, with an ESA. But you're entitled to have rules, picking up after the dog and not incessant barking and not letting them out on the balcony. I mean, there are documents that say you have to carry your dog. If the dog goes 70 pounds, that might be a little difficult. But, other associations have rules that if you're in a common area, you're going through the lobby, that dog got to be on one of those little, carriages, strollers for dogs. So there's all types of rules like that that you can enforce.
Can't you prohibit a tenant from having a pet?
Yes, but not if it's an ESA.
So even if it's a ESA, we can make a rules. Reasonable rules, yeah? I have another question, not about pets. Can nuisance, if the resident is the tenant, can nuisance be a reason for the association to not renew the lease?
Yes.
So what is it?
If there's a tenant, I mean, let me just say this. Most associations, right, have some type of process to approve tenants. So if there's a tenant, and you generally don't approve a tenant for more than a year, So if there's a tenant in there that's violating the rules and causing a nuisance, then you let the unit owner know, we will not approve a renewal of this lease, and you need to let that tenant know.
And there is a process to that. You have to prove that, I mean, the grievance committee have to find you guilty, have to confirm violation first. It's not like the management state that you are violation of the rule, and the grievance committee has to find that person responsible of violation. So it's actually become a violation itself, and it's receive a fine for that. Because as a property manager, you can send violation notice to someone if you are doing A, B, and C, and then they go to the grievance committee, and grievance say, hey, you are not confirming this violation because you didn't have enough evidence to do so. And at that point, the violation goes rule. And that's our issue. Grievance committee, as you said, are sometimes difficult to create.
Well, so I've gone so far as to file lawsuits against the unit owner and the tenant because the tenant wasn't approved or reapproved, or the tenant was causing problems, in the building, and I've had those tenants removed. Basically, it's a mandatory injunction forcing the unit owner to get that tenant out. So
what
it's an
you're saying-
extreme case, but you can do it.
But what you're saying is, okay,
I know you were, she was fucked.
oh, sorry.
The procedure for that, like they have to notify the landlord or
Yes.
they have, notify.
Right, the landlord is responsible for the conduct of the landlord's tenant. And if the tenant is violating the rules over and over again, you need to let the landlord know what's going on and that it's a problem. And yes, if you can, fine and go to a grievance committee, that's fine. Then you have more of a record, but you might just have security reports or, emails with all types of complaints about this particular. I have one. Here's one. This is a unit owner on Miami Beach who we basically think is running a homeless shelter. He has no money, and he's like letting people come in, and they have cameras every day. The guy's coming in, and I filed an action for injunctive relief against this unit owner. I can't force the unit owner out, although we are foreclosing a condominium also. So one way or the other, but you can't, as an association, let this type of conduct go on. And there are remedies such as injunctive relief.
Our tenants, they have 3 kids, very sporty kids, and they were running around the apartment, and the people underneath, they were complaining all the time that they are constantly making a nuisance and
Stomping on us, running barefoot, right?
I have no idea how they were running, but
That's very
people
common.
downstairs will constantly complain about this situation, and we were talking with the parents and whatever, try to solve this problem, and then we moved them to another apartment because we thought maybe the guy underneath is, like very sensitive, yes, or something like that. So, and we had the same situation in another apartment, so the people who live underneath, they also complained. So it was like a pattern, like they were running constantly. So and their kids, and another kid, and another hand, it's their kids. So how to solve this?
Listen, unit owners have more rights than tenants, in my opinion, and you try to put, sounds like a reasonable solution. You have them move from one apartment to another to see if it works out, but if it's not working out and they're causing a disturbance, now if you could find a ground floor unit, that could be a different story maybe. But
This is a more profound question.
Right.
It's a nuisance.
Right.
It's just by virtue of being a kid, are you a nuisance, right? To a neighbor, right?
It's not in use.
Just by being kids, just as
For emotional support, one of them, like, right, how many dogs, how many emotional support,
You're right, there's no limit, yeah.
and inside,
Yes. As many. In fact, I was asked to pull a restriction from my documents that limited it. In my documents that I draft, I limited to two dogs or two cats, or a combination. And I was asked to remove that from all the documents to this because it was too restricted. Now, I don't know if there was a HUD guideline or something like that, but historically, you would try to do that with pets, but you can't do it with emotional support animals or service animals. But it's crazy because how many support animals does a person need? Like, why isn't one enough?
Leave the dog unattended
Yes, but then that creates a nuisance.
How much emotional support does a person need, right?
The doctor decides.
The dog decides, so. But these dogs are, clearly dogs and other animals can really present a potential nuisance, right? I mean, think about it. It's noise. It's also odors. It's, but no ability to limit the number of emotional support animals. Did you have a question?
One owner, say on the
an owner on the fifth floor complains about the owner on the sixth floor making a lot of noises. And then when we talk to the sixth floor owner, the owner said, I'm not aware of any noises. So we have asked the fifth floor owner to record excessive noises.
I would think so.
I think so.
Right. I mean, you need some type of. There are buildings. I'm not saying that yours does, but in the building that I was talking about on Miami Beach, where the person was playing the music loud and so forth, they have that security, and so security would come up and they would record it. But most buildings don't have that, so somebody else other than the persons in that unit on the fifth floor needs to be able to come up and witness that. Maybe it's a board member, maybe it's a manager.
That's right, corroborating. Not only noise, proof of noise, but corroborating evidence, right? You need to prove. If you think there's a nuisance, it's always a question of proof.
Right, and you want to have
what is the level of the nuisance?
But you want to have a record. So-and-so called, Mr. Smith called at, 1 a.m. on such and such a date, and Mr. Smith called at, 2 a.m. or 11 o'clock, on another day. So you have like a record of all these incidents where somebody called, where it may assist you in corroborating the fact that there is a violation, without just having to rely on that individual saying, I hear noise all the time. Because maybe he's already sensitive. We don't know.
Sorry, quick question. Did you heard anything about new law or regulation that every single pet must be insured with homeowners insurance?
No.
I heard something like that.
Okay, not
I'm not
yet. What about odor nuisances? What about odors? You ever have any of those, any arbitration cases, what about the neighbor cooks, Like my husband is very sensitive to, no garlic, no this, no that, some people don't like the cooking style of the next door neighbor. It's not in use.
I think the word in the law is reasonable.
Reasonable.
What is reasonable? What is not?
What is the test of reasonable? So for example, like my mom has tinnitus, right? And she plays the volume in her TV extremely loud, right? But she also has sensitivity. And so do you take your plaintiff as you find it, right? Is it based on that person, or is it a reasonable man standard? Or does it just depend?
I think it depends on the circumstances, but it also has to be reasonable. And in terms of odors, it's not only cooking, it could be incense, and people like to have lots of candles burning in their unit and things like that. And again, the question is it so unreasonable to the neighbor?
No. Because it's like a taste.
Right. Okay, harassment. Okay, I've heard that there is an anti-harassment policy in one of the Winston Towers buildings. Is that correct? Yes, there's a harassment policy in one of the listed buildings. Yes.
So,
I've heard. So the question is, threatening behavior, harassment. Does your association have a harassment policy? Is harassment a nuisance?
yes. So here's a case.
Because I always say, what is the tort of harassment? Because I always say, like, somebody's harassing me, they're harassing me. What do you do about that? There's no common law action for harassment, right?
If it constitutes a nuisance.
But if it constitutes
So
a
here's-
nuisance, so how does that work?
Right, so here's a case. This is an arbitration case from 2022. The petition filed by the association alleged that the unit owner had created a nuisance by damaging a common element door, harassing residents and vendors, filming people without their permission,
Oh,
harassing owners regarding their parking spaces, and blocking owners from using their parking spaces. And the arbitrator found that that did constitute a nuisance and entered an order, enjoining as an injunction, basically saying you can't do that. Here's another one. This is another order from 2022. And this one involves, okay, there was evidence that the unit owner had engaged in conduct that's bothersome and entirely uncalled for, as far as suggesting physical violence against the manager of the building. He had also made himself, what the arbitrator said, a thorn in the side of the manager. It's actually a she. Her conduct had interfered with the operations of the condominium and effectively and unreasonably interfered with the manager's ability to address association matters. There were excessive emails that distracted the manager, and her conduct created unreasonable and negative impacts with respect to her unit owners, and she was enjoined from that conduct.
okay, so
On a
it's a
nuisance basis.
so now we know that harassment can be the basis for a nuisance action or nuisance. What if it's the board member that's harassing the manager? How does that work? You think
Still a
the
nuisance?
manager? You think the manager has a right of action against a board member for harassment? Or is it just the unit owner that has a right of a right of to
No,
claim
this would have to be the other board members, voting to bring action against that particular, the board member who was interfering with management. Or no,
But is it actionable if can a manager claim that the board member is harassing the manager? Is that something that's plausible? How can you get into arbitration on something like that?
well,
Do they
the
have
association
standing?
has to file it. It's still a unit owner.
Oh, it's the association
Right,
that
the
has to file
association
it.
would have to file it against the unit owner.
So the manager doesn't have standing.
Right.
Standing meaning you can't sit in that capacity, or you can't stand in that capacity. Standing is right. But what you're saying is the manager cannot pursue an arbitration directly. It would have to be the association on behalf of the manager.
That's correct. And that's what happened in the case that I was just reading from.
And what about a unit owner against another unit owner? How does that work?
Well,
Can a unit owner claim a nuisance and arbitrate because another unit owner is harassing, or say a board member is harassing that unit owner?
you might have an action but for injunctive relief, but it's not an arbitration case. It's not subject to arbitration, so you have to go to court.
Okay. Any other question?
I almost wanted to answer that question. That one is harassing unit owner who is asking inconvenient questions. There is the unit owner who has his right to ask questions, but board doesn't like those questions. And they're starting to harass the unit owner. In this case, what can you do?
No, I haven't seen that before. I'm not certain.
No,
I'm not certain that maybe the unit owner can't file a petition for arbitration against the association, not against the board member, but against the association. Because the action of the board member constitutes a nuisance because he's interfering with the rights of a unit owner. That's a good question. I've seen that.
Board is sending email. Board, association, board, property manager, every day sending email.
So you know what I would do if I were that unit owner? I'd organize a recall. Get rid of those board members. That's what I would do.
Okay. The question is, what if, and you mentioned that a unit owner interfere with the daily work of the manager and management office with numerous discoveries, emails, documents, nonstop. You did the production of it was giving everything nonstop. I mean, this is something that, of course, they have a right to inspect and 10 days to produce, but this is not ongoing. I want this, I want that, and every time a new request going on, and that's a nuisance.
Yeah, I mean, I think that's similar to the case that I was just reading from. And the association, you can adopt reasonable rules and regulations just because the unit owner has the right to inspect documents or request documents. Remember, it's 10 business days to produce them. And you can limit the number of times per month, for example, that somebody can ask for records and ask for the same thing over and over again, because it can become abusive. You know, you're abusing your right as a unit owner to inspect records.
But again, aggressive
Right.
behavior that has some corroborating witness or some corroboration or some quality
Could be a nuisance.
could be a nuisance. And I want to acknowledge Commissioner Alex Lama just walked in. Alex.
I have a question.
Should everything be on their website to view anyway?
So a lot of smaller condominiums don't have websites, but you're right. I mean, now that the law effective as of January 1st is that any condominium association with 25 or more units must have a website.
Correct.
And all of those documents have to be on the website. So it becomes a lot easier for the manager to say, it's on the website.
Yes.
Oh,
All right.
there.
And with the new checklist, Okay, with the new checklist system, you can point to that.
Yes, my question goes back to the question that you asked. I've been dealing with the noise nuisance for about 5 months now. I have done everything that I thought I have to do according to the rules and regulations, lighting, and so on and so forth. She asked when the owner above you is creating this noise, which sometimes is throughout the day. My walls are vibrating. Sometimes 11 o'clock at night, and it goes on to 3 o'clock in the morning. When I call the front desk to have someone come in through the day, someone can come upstairs to hear it because I need somebody else to hear it. That's through the day. At nighttime, when it's really loud, because the dead of the night, everything is actually much more louder. There's only one person at the front desk. No one can come upstairs.
Did you try to record it? Did you don't?
It's very difficult to record. I was only able to record it on New Year's Day. I have it here. When it's so loud, here I am standing on top of my bed recording it. Otherwise, when I try to do it, it's not, with the phone, it's not loud enough. I was even thinking of buying like a special equipment so that I can record it. Now, my issue is this. I was told that through the day, even though my walls are vibrating, they're not, the front desk is not recording me making that complaint because it's through the day. When it's at nighttime, yes, after 11 o'clock at night. So I live in this beautiful condominium, corner unit, huge apartment that I invested a lot of money in. And there's no way of protecting me. The association is not protecting me. The property manager has refused to answer my emails. I have emails, I have letters to the owner, giving him my phone number, my email. Let's meet, let's talk about this. Make noise through the day. Don't make noise at night when I go to bed. I haven't heard from anybody yet.
Can I give you a solution that happened in our association?
Please.
The owner called the police, and Sunny Eye police
That's
come to the place,
okay.
knock the door,
Okay.
and stop the problem.
Exactly.
So
Wait.
go to the police.
Yes.
People start making 1, 2, 3 complaints, and then you can go to the attorney and say, you see, police coming here. This is the best
Thank
solution.
you.
Coming in our building, Stop this problem.
Everything I hear is it has to be after 11. What happens during the day when I'm home quietly
But
reading?
what is reasonable for them and for you sometimes is different.
Yeah. Why
Better
does
that
it
they
have
were
to be after
reasonable.
11? So that I cannot enjoy my apartment from 8 o'clock in the morning until 11 o'clock at night? After 11?
Exactly.
Yes, before the day. Why do I need to hear my house vibrating?
Because the walls are together.
No. It's a TV.
It's a TV. Y vecino pone la música toda la el fin de semana.
Well, just because it's not after 11 and before 8 a.m. doesn't mean it's not a nuisance. And it's not a violation of the noise ordinance, but it's still a nuisance. And, somebody said, going up front, call the police, and I don't know if he'll come during the day, but keep a record of every time.
I have it on.
Okay. So that's part of the evidence, and if it really is unreasonable, maybe get also a decibel meter, to record, how loud it is even during the day, because you are entitled to quiet enjoyment. As we said earlier when we started off, living in a condominium building with neighbors, you're going to hear noises from time to time, and you're going to be disturbed at times. But if it's incessant, as you say it is, then you need to keep records, and you may want to consider filing a lawsuit against your neighbor.
I do recommend that very thing. They say call the police. Call the police. And you do it repeatedly, and you have documentation. Absolutely, I do recommend that. Well, isn't this a code enforcement issue more than a police issue?
It is a code enforcement issue, but going back to this point, so we've been discussing, I think you're part of some of these discussions of perhaps assigning some places where they could unload the trucks. And then the last conversation we had among ourselves, the commission, is getting in touch with some of these companies that bring these cars down, communicating with them so they could abide by certain, perhaps rules, courtesies, etc. So, but the main point is that we're looking at perhaps assigning a couple of spots in the city where they could unload these trucks. And also, I don't know if this could work because I see them driving down, but also limiting to certain times of the day. So that's the last discussion we had. I would need to go back to our city manager and see where we stand on that. But yeah.
Okay, the thing is, at this time of the year, it's cold. You don't have the AC on, so you open up the window, and the noise is so, even the pool is nearby the sidewalk, and it really bothers everybody. I don't know, it's just trying to operate the great station there. I think,
It's a great case. That's the trial court case. Did you have a chance to look at this? So again, just to reiterate, this is Merrill versus Bosser in 2005, the Broward 17th Circuit, a trial court decision. This is not a case about secondhand smoke. Rather, as persuasively argued by the plaintiff, it is about excessive secondhand smoke. So there were actions for trespass, common law nuisance, and breach of covenant. And they were all granted, right, by the trial court. So, trespass, disturbance of possession with smoke may be committed by discharging a foreign polluting matter at a point beyond the boundary of such private nuisance. There must be an interference with the use and enjoyment of land, and such interference is wrong only to those persons who have property rights or privileges in the land. Breach of covenant, of quiet enjoyment, breach when a party obstructs, interferes with, or takes away from another party in a substantial degree the beneficial use of the premises.
That could apply when there's more marijuana.
Again, it would be what is considered excessive. So if you have the smoke coming in through the vents, does it happen once a week? Does it happen all day long? You have you know, people smoking pot all day and all night long, and the odor. What if you have kids? And if you have kids in the hallway, do you want them to be exposed to marijuana smoke, incessant or excessive smoke? I would think that you could successfully claim a nuisance on marijuana or excessive. I think it's about a degree, right?
Correct.
Can you prohibit owners from smoking on the balcony?
No.
Yes.
I mean, I think you can prohibit them from smoking anywhere on the property. I mean, that's
Except for in the unit.
No, I've done amendments where you cannot smoke on the unit, and we tell the unit owners if you want to smoke, you can go on the balcony.
Oh, you can go on the
Right,
balcony.
but I mean, it depends on the regulation that the association wants to impose, and what the unit owners, because it's a limited declaration.
Yes.
Right.
Prohibit smoking on common areas.
Right. So,
That I could see.
right.
So what do people do if they buy a unit and they can't smoke anywhere?
Well, they have to know what they're entitled to a copy of the Declaration of Condominium before they buy, and so it's up to them to determine if they're a smoker, whether there's any regulations in the building which would inhibit their ability to smoke. I mean, that's really what it comes down to. You got to
And
do due
even-
diligence.
But what if they have a medical issue?
Oh.
What if
So
is
medical
marijuana legal in the state of Florida?
Medical marijuana is different. I mean, you can't stop somebody from taking the medicine, but I suppose you can say, do it on the balcony, so that the smoke is not going through the air vents to the next unit. And if you know your neighbor, smokes, and if you're friendly with your neighbor, I could just say, let me know when you're going outside, and I'll close my sliding glass door, and so, just being neighborly about it.
Anybody here have an issue in their condo with secondhand smoke?
And the thing is, sometimes it's not easy to detect who. People, when they complain and they say somebody's smoking, it's very hard. Unless if they can nail down and say that's my neighbor or both, we can go and chase all the neighborhood and everybody around it, because smoke travels through the air ducts, through the fans, the ventilation system, through the AC system. So there is no way for us. So what I do, occasionally I send a blast to everybody that smoking is prohibited inside of the unit, respect your neighbor, all that. So that's all I think. If they cannot come to me to tell this is the apartment and we know they're smoking, like a manager really cannot do anything about it. I have to go and, know exactly who did it. And if I'm gonna send my maintenance or security or their own go case it, nothing is gonna be done on buildings. So this is becoming a very big problem now.
What about, can't you get like air purifier or some sort of a mitigation, or can you get like are there systems where you can take the smoke out of the air, or put it in the common elements?
Special HEPA filters installed in citations.
Filters. So you can install them, right? But you can't always find the source. How would you know if somebody's like a unit owner smoking, or?
I mean, if you're walking down the hall, you probably smell it from,
Yes, that's interesting. So a lot of people have had that experience, right? Where you have smokers, because a lot of people have great sensitivity to it, right? In this particular case in Broward County, the people had like respiratory or respiratory condition or some medical. Then they have, again, you take your plaintiff as you find them, and if you have somebody had a history of cancer or something like that, who would want to live next to somebody who's a heavy smoker? It's your health, right?
And I honestly don't know. I don't think. Listen, there's still people who smoke, but not the way it was years ago. I can't imagine that it's all that difficult to get a sufficient number of unit owners to vote to pass an amendment to prohibit smoking in units. So
But the documents have to so state,
Right.
and it can't be in the rules. It has to be a declaration.
Yeah,
So in my building condo declaration, owners can smoke outside of the deck, right? Not inside, not in the balcony, but outside. So first question is, open air parking garage, is that considered outside the building or not? And the second question is, one owner complains about another owner who said he has medical marijuana certificate, and he showed the property manager the certificate, but the owner doesn't trust that. She asked for the copy of that owner's medical marijuana. He said no, right? The
Copy of what?
medical marijuana, that was not
Is that was like HIPAA? Is it HIPAA? You know.
No, I mean, I think that you said the manager, the unit owner showed the manager a copy.
That's okay, but the owner, another owner cannot request property.
I don't think that the owner who has the medical marijuana certificate has any obligation to show it to a neighbor.
So the property manager cannot show to that second owner.
Well, the property manager can say, I saw it.
Yeah.
It's all.
So you
Open air garage. Is that
It's really not outside. It's still it's partially enclosed, right? It's unfair.
Alex?
No, it's an open parking lot. That's one thing. But you're saying there's a cover, but it's not fully enclosed. Right. I mean, I would say that it's not outside. I mean, if you're going to your car, why do you have to smell, the smoke or find cigarette butts and things like that? That's the way I look at it.
Yeah, so there's one instance here in the city where this couple has a little girl and one of the neighbors smokes a lot of pot. And I've tried to help him out by then calling the police. The problem is that he says that it is for medical purposes. So it's been going on for a while. The management of the building has talked to him, so he doesn't smoke as much, but it's kind of a problem when they state that it's for medical purposes. Because obviously there's several laws involved, and like you stated, Robert, I mean, the person that smokes marijuana doesn't have to show any certificate or anything stating that he needs it for medical purposes. So it's kind of a problem because this couple has a little girl, and it smells like pot all the time, and now you have like neighbor versus neighbor, and unfortunately I wish I could help them, but because of the medical issue, it's a little difficult. And then the building has tried to talk to him, but it's not stopping. So I don't know what can you do with that instance. I mean, maybe take it up with a lawyer. I mean, what happens? Something like that happens.
I mean, I had that situation where I got a call. It was her parents who were tenants they were tenants in a condo, and I just said, if the management is willing to move them to another unit, that's the best solution, because there is no other way other than to move.
Couple.
If there were tenants, they were just lucky enough to have another unit in another area of the building, and they were able to move. And I urged them. I said, "You're not getting this guy to stop his smoking. So the best for your parents is to move them." But I agree. If I had little children and there was somebody who was smoking all the time, who would want to? For me, it's the
prescription.
Yeah.
It's a medical
I feel bad.
But for me, the excessive smoke and the exposure to minor children, for me, is a classic nuisance.
Maybe a remedy again, forcing this person, I don't know if it's to smoke 24 hours a day, to hit the balcony or to go outside or,
That's a disadvantage of living in a building.
Yeah.
But it's medical. The livable
And then, well, what about all the fun of living condo living? Right? Well, it's so much fun living in a condo.
Can you help the doggy? Can you tell that person that needs the medical marijuana to take doggies instead?
I think that's your uncle.
I guess you can ask him to talk to his doctor. I suppose you could ask him to speak to his physician to see if that's an alternative for him. But I mean,
Forced filtration systems, right? You know, mandatory filtration, right? I'm a property manager, and I currently have the same situation where there's a building with the child. The resident next door is a tenant who smokes pot and has medical marijuana. Now, I spoke with the owner of the unit, and he's not renewing his lease, so he's leaving in 30 to 60 days. But that owner with the child that's not good enough. She wants immediate, and there's nothing I could do. I mean, we have done as much as we can. Would her next defense be going to arbitration? With it? Yeah.
Well, she can't go to arbitration because it's owner versus.
Or whatever. Can you imagine if the problem exists with medical marijuana? Can you imagine if a referendum allowed for recreational marijuana? What kind of issues would arise, you know, in these common interest communities and condominiums, right? It's something to think about, right?
We can all do it.
So let's talk. Okay, we have AC systems, noisy things. I think those, the AC units, the noisy units, that stuff. I think that's clearly actionable, right?
I agree.
As are helicopters, because there's a big case about that. So helicopters landing. Okay. Do you have any other noteworthy arbitration decisions, or let's talk about best practices?
Not really. I mean, this is hopefully we will never experience this again. But back in the COVID days, when the associations had rules and regulations about wearing masks, particularly if you're in a common area or in a common area or in an elevator, there were unit owners in this particular condominium who refused and were very aggressive about the refusal. Ultimately, they were ordered to comply under those unusual circumstances. So, we hope not to have to live through that again, but people have got to comply with rules.
Let's we're essentially after 8 o'clock, so we're gonna wrap up. But anyway, you have one question, Marie. Go ahead.
For the site part of your, because you didn't speak about site.
Site.
Site. So we have a situation in our development. We have 3 towers, anti-urban house, and the 100 has been in construction for their parking lot for years, like 3 or 4 years. It's been a disaster. We are doing great. We're both on the board. We're 2 board members at 300. We're doing phenomenal at 300. 500 working on their stuff. They keep allowing now these illegally commercially marked vehicles to park on Bailey Drive. It's been going on for a year. There used to be 1 van, now it's 3 vans, now it's 5 vans, now we're up to about 6 or 7 vans of commercially marked vehicles. Pink, blue, orange, all sorts of colors. We've asked them 1,000,000 times. We've sent them emails. They're claiming that they've temporarily allowed them to park there, but it's temporary for a year or more. It's been a little over a year now. And it's more and more. So more people are moving into our development, which all 3 buildings have no commercial parking, no commercial vehicles allowed. They're renting, they're all tenants, not one owner. All tenants, they're renting in this 100 building just to advertise. I mean, what do we do? We don't know what to do. We're like ready.
We've called code enforcement so many times that they told us stop harassing us.
And everyone feels
So are you talking about commercial vehicles that are the tenants or the owner's own? Because there is a new law on the HOA side that says that if it's your commercial, if you have the lettering and it's your commercial vehicle that you're allowed, you cannot be prohibiting. But it's not a condo, it's an HOA law, and so it doesn't necessarily apply. But I would think that there are, in other words, things like there's new laws that came in, open pickup trucks and, vehicles that are not commercial vehicles, but vehicles that have if you're the Avon lady and you have an Avon, magnet on your car, that's okay. But if your commercial vehicle for your
Is that
business,
a public road? By our,
It's our shared, baby drive between a small free building.
so in other words, you're saying it's a private road?
Yes, it's
Okay.
all private.
so then what, if
So
you're
then-
governing
So then
documents,
you have a master association that governs? No, you don't. Okay.
the 300 and the 500 are, right.
We're all separate.
But you all have separate covenants, and so
management stuff.
and so do they prohibit these types of commercial vehicles?
Things bylaws prohibited commercially marked vehicles. Everyone, even in the 100 building, is out here.
Can you put up towing signs?
We told one guy, we told any of their,
It's the
buildings, vehicles, and.
Oh, so because you don't know, right? You don't know which building that those vehicles will belong to. Okay, right. I get it.
So it's a very close situation. It's a good. It is a violation of the bylaws of all three buildings.
Well, why are your neighboring buildings not forcing the bylaws then? Because you said when you towed one vehicle and 100 building, whichever one it was,
Yeah.
Not in your case, if you do it again, or you take action
Well,
against
the
them.
manager was now like, go there, the manager is still KW, and they just don't want to be bothered with that. They're like, sorry, you heard the construction, there's nowhere to park them. How is this our problem? There's 1,200 unit owners. All three buildings, it's 1,200 units. I mean, it's not little.
They can't park these vehicles in the garage, so they're not in plain sight.
That's what I've been suggesting.
And I don't think you're right, clearance.
No, there's they can't get in those arena.
Right, they can't go.
And it's once,
They usually walk up front, on the east side of the building where they come into the center entrance. But that's been dirt now for 2.5 years. So
Right.
it's closed. And it started out, I would say, one electrician's vehicle, ABC electrician. Now there's 3 of those vehicles there, but now they're like, well, they're letting us walk here. We might as well save on parking fees and use this for free. So they close that.
One of them is even having his employees come in the morning, so I found out.
so these are not unit owner owned, these are actual construction.
No, they're renters.
Oh, renters,
They
yeah,
rent an apartment just to park these vehicles in. I mean, it's crazy.
that is crazy.
So,
It's insane what's going on.
so tell the owners you're not going to renew the leases. Tell the owners.
It's not our building.
It's not your building.
It's the one exactly building.
They should be working on that parking area.
Entrance out of all our buildings.
First thing you see is all these.
And we have a beautiful marina, and it's blocking the whole marina. So when we used to have beautiful water viewing all the boats, now you can't see anything but commercial vehicles when you come in.
No, under air parking.
Yeah, I don't.
No, it's a massive parking lot in the very east portion of the property, but they haven't completed yet, huh? It's still working
It's
progress.
not even a construction traffic site. Nothing's happening. Nothing's happening.
It's crazy, and it's a big parking lot. It's really a shame because that really takes up so much space.
So if you have any ideas, think about it.
We'll think about it. Okay, just to spitball some best practices for me, are the governing documents clear? Do you have examples of prohibited conduct? Are your rules specific about what's prohibited? What are your association's enforcement procedures? Do you have a violations committee? Do you routinely issue violations? You want to be careful you don't enforce selectively the rules, right? So that somebody can come back and say,
As a defense,
and just be precise. And if you're the person, the complainant, you got to get your ducks in a row, right?
you're right.
Okay. Any other best practices? Any other ideas? All right. Thank you so much. What a great presentation, great discussion. Thanks for all the interaction. Stay tuned for our next Chamber of Commerce presentation. We'll have one next month. Thank you so much. Thanks for coming. Thank you for all the input. Pleasure. Thanks.